This is Greenwood's Legal's Employment Law Nowcast, episode 10. This is part 1 of the case law quiz. Enjoy the podcast. Hello and welcome to our Employment Law Nowcast. You'll see it's a bit different today because I'm by myself. John and Keith aren't here, but you will be seeing Keith in a minute because in this podcast we will be bringing you a clip from one of our recent events that we have held in Peterborough and Cambridge. So that was from our Employment Law Now Live event, and you'll see in a moment that Keith has done a case law quiz, and we think it's really a helpful way to learn and to recap the most interesting cases over the last year. There are no prizes, I'm afraid, if you're joining in from home, but if you do get full marks, do drop us an email because it's not an easy quiz, so we'll be very impressed. And over to Keith.
I'm going to move straight into the first question, and here it is. It's about settlement agreements. So long-standing employee. This may feel like deja vu if you're here this year, but bear with us. There is method to the fact we've got this question. A long-standing employee, 61 years old, volunteers for redundancy. In return for an enhanced redundancy payment, he signs a settlement agreement waiving his right to bring claims, including future claims that he was not aware of. The redundancy enhancements in 2 parts. The second part payable 6 months after termination and subject to a separate agreement which limits payments to employees under the age of 61. When the agreement was signed, it was your intention as the employer and the employee's expectation that the additional payment would be paid, even though he was 61. However, shortly after the agreement signed, you decide not to pay the additional payment to employees over the age of 60. And this employee brings a claim for the additional payment. And the question that you're going to have to answer in a minute, perhaps that's steady on, in a minute, has got one of these 4 answers. So can the employee bring the claim notwithstanding the settlement agreement? And we got 4 options. No, because particular complaints can include future claims. No, he should have read the separate agreement, then he would realise he was entitled to the additional payment. Or C, yes, settlement agreements can't settle direct age discrimination claims. Or D, yes, because settlement agreements can't settle claims that only arise after they've been entered into and which the employee wasn't aware of. So what were the answers in the room? So no particular complaints. That was the lowest with only 5%. Yes, settlement agreements can't settle direct age discrimination claims. C was about a third of the room. Almost half the room was yes, settlement agreements can't settle claims that only arise after they've been entered into and which the employee wasn't aware of. Congratulations to everyone who was here last year answering the question, who said D, because you were right last year. But this year, not so much. And the correct answer is A, no. Now, particular complaints can include future claims. This, same case as last year, but last year it was not at the Court of Session. The Court of Session is the highest court in Scotland. And so we've reached the end of the line with this case now. And according to the Scottish Court of Session, then yes, you can settle claims in a settlement agreement that the employee didn't know about, that didn't even exist at the time. And so it would have been, it's a claim that would have to be settled through a settlement agreement because the practice that was being implemented was age discrimination. So he potentially had a claim. And settlement agreements, as if you're people that have dealt with settlement agreements previously and seen how long they are, and the fact that you get in at least usually 2 places in a settlement agreement, you get a great long list of claims. That is because the legislation says you can only settle particular complaints, and you've got to spell out what those complaints are in the settlement agreement. And there has been, for a number of years, a lot of legal uncertainty about whether you can settle claims that haven't come into existence yet. So can you settle future claims? And The previous iteration of this case that I was talking about last year came down on the side of no, you've got to be able to identify the particular complaint, and if a complaint doesn't exist yet, it's not capable of being identified as a particular complaint. And this case has overturned that. So now you can, as long as you're really clear about what you're settling, you can settle future claims as well as past claims. It is a very technical point, so I don't think this instantly answers all of our questions forever. I don't know if any of you have ever had to deal with the settlement agreement where you've got a reaffirmation clause or something like that, where the employee has to sign it again later on. You especially use them where there's quite a big gap between them signing the settlement in the first place, but their employment doesn't terminate for some time. And that whole reaffirmation exercise is to deal with claims that arise in between when they sign the settlement agreement and when their employment terminates. There's an argument that says that with this new case, those are a thing of the past now. I think being lawyers, we're quite cautious about new things. So I think there is still an argument for using reaffirmation clauses for the time being, to ensure that you don't fall into a legal gap. But I suspect that in the fullness of time, and we will see further cases on this that I think will confirm the case or question it. I think we may get to a point in the not too distant future where those reaffirmation clauses aren't needed, because the settling of the future claims in the original settlement agreement will just do the job that it's supposed to. But watch this space on that one. It's worth noting that this is a Scottish case, and the Court of Session isn't binding on English and Welsh courts in quite the same way as, say, the Supreme Court is. So there's a potential argument that a UK tribunal or higher court could not follow this. I think it's unlikely. It's not impossible. So where we are, there's been a whole string of cases on this, including a number of years ago now, Hinton, that first said, well, as long as you've done enough to particularise the claims, it's enough. And that's where we are now. So as I say, I think perhaps some slightly straightforward times ahead of us in settling claims with settlement agreements. I'm going to move on, though, to the second question today. Just out of interest, if you're really, if you're happy to, who did get that one right? Hands up. Yeah, not many people are owning up to that one. So you're definitely in with a shout for the prize. You're one ahead of almost everyone else in the room. Moving on. Unilateral changes to terms and conditions. So the facts of this one. So in a restructure, a specialist nurse fails to secure a post in her current Band 6 role and is slotted into one in Band 5 under new terms and conditions. She refuses to sign, arguing that the role is generic and does not require her specialist skills. She raises a grievance and says that her role should have been made redundant and she should receive enhanced redundancy pay. This is not paid to employees that have left before the expiry of their notice. Apologies for the facts on this one. It gets incredibly convoluted, but we'll try and stick to the useful bits. She dismissed by reason of redundancy and is served notice, but then, I still can't quite work out why, she resigns before the expiry of her notice period, and she's told that because she's done that, she's no longer eligible for the enhanced redundancy payment. She brings a claim for unfair dismissal and redundancy pay. She argues that her dismissal is a hog dismissal. That's the case of Hogg and Dover College that we'll talk about in a bit, i.e. a unilateral variation of contract, which amounts to a termination of one contract, the Band 6 contract, and its replacement by another one, the Band 5 one. If it's a hog dismissal, she's entitled to the enhanced pay. So the answers, options we've got here. Can this dismissal be classified as a hog dismissal? No, the claimant had the skills to do the Band 5 role. Maybe, it depends on the facts. No, there was no intention by the employer to dismiss. Or yes, because there was a radical change in role. In terms of the answers, so just about winning. No, there was no intention by the employer to dismiss. exactly a third of you, maybe, it depends on the facts. And about 1 in 5, yes, there's a radical change of role. Well, that's about a third of you have got the right answer on that one. Maybe. It depends on the facts. And this actually, it's a helpful reminder, this case, of what the role of the EAT is as opposed to what the Employment Tribunal is, because what the EAT found here is that, well, there's legal arguments pointing in both directions, and that's their job to look at the legal arguments. But other than in quite rare circumstances, it's not really the EAT's job to actually decide the outcome of the case or decide on any factual matters. So this was the case of Jackson and the University Hospital of North Midlands NHS Trust. So it went to the EAT. The tribunal had said that the employee wasn't entitled to enhanced redundancy pay. There was no hog dismissal. Hog is sort of ancient news in comparative terms in employment law. It's a case from back in 1990. And you don't get too many 33, 34-year-old cases that are still relevant in employment law. It usually moves quite quick, a bit quicker than that, but not this one. The hog dismissal doctrine is still alive and well. What the AT found here was that essentially the Employment Tribunal had focused on the wrong things. What they hadn't done properly in the AAT's view is look at the Band 5 role and the Band 6 role, so the sort of the before and after roles, and do a clear and detailed comparison of whether shifting, so slotting her in from a Band 6 role into a Band 5 role was a change in terms and conditions, or it was effectively taking away one job and replacing it with another job. And that's the crucial thing here. Is what we're talking about tweaking or changing some terms and conditions, or is it effectively the end of one role and the start of another? Because if it's the end of one role and the start of another, that can be a dismissal and that can be a redundancy, even though the person is still employed. And that's the point of the hog dismissal. That's what a hog dismissal is. What the tribunal did do is look at some what the EAT considered were irrelevant facts, like the fact that she had the skills to do the new role. That's not relevant, said the AT, to whether she's effectively being dismissed. So yes, she did have the skills to do it, but that's not the point. You can't just shift someone into another job because they've got the skills and not suffer any consequences. And the tribunal also looked at the fact that it was never the employer's intention to dismiss this individual or anyone else, for that matter, in the process. They wanted people in the new role, and again, the AT said that's not relevant. It's not about whether the employer intends to dismiss. It's the actual effect of their actions that we need to look at. So what the EAT did here, they said, look, this could go two ways. Maybe it's a hog dismissal, maybe it's not a hog dismissal. To be fair, they sent a fairly clear message that they thought it probably was a hog dismissal, but they still sent it back to the tribunal to take another look at, rather than deciding it for themselves, which is why we don't know exactly what the answer will be. But as I say, the EAT have sent quite a strong message. So why is this relevant or important for us to be talking about today, given that actually hog dismissals are quite rare as a legal thing that you see? For me, it's really tied to all of the issues that have been coming up recently and are going to continue into the future about dismissal and re-engagement, or fire and rehire, as the papers would have it, because this sort of stuff is all around the employer wanting to get people onto different terms and conditions, and fire and rehire, dismiss and re-engage, is becoming a bit of a dirty word now, and there are restrictions, and there are going to be restrictions on what you can do and how you need to go down that. So it might be quite tempting for employers to think, well, I don't need to actually dismiss anyone and re-engage them. What I can do is just change their terms and conditions, and that's fine because it's not a dismissal. Well, turns out it could be a dismissal. So it isn't the easy answer. to simply unilaterally change people's terms and conditions. You might end up inadvertently dismissing people in legal technical terms, even though that was never your intention. So where you're looking at changing terms and conditions and there's anything significant, if it's really trivial changes, maybe not so much, but if you're looking at any significant changes, you really need to be alive to this fact. And what that means is you need to have got your ducks in a row before going down one of these exercises. So actually think really clearly about what the changes are and whether they can be justified, whether they can be explained to the employees, whether they really amount to asking the employee to do a different role, and consulting with employees, because you can bet your life, even if you haven't thought it's a problem, if you start consulting with your employees, you'll find out if it is. So that can flush out those issues at an early stage before you're sitting in front of the AT being told you've dismissed a bunch of people that you never intended to. So it is worth, with any of these sorts of exercises, taking advice at an early stage and making sure that you're on track with how you're planning on doing your changes. But I'm going to move on now. I'm going to check the time, not so bad. Holiday pay case next. So based on, there will come a time when we're not talking about holiday pay at one of these things, but not yet, not today. So based on the entitlements set out in their employment contracts, you've been paying employees holiday based on their basic rate of pay rather than their normal pay. Their normal pay includes overtime and certain allowances. Now, people all around the room will be thinking, that's a bit old school, because it is a bit old school. So you agree with your employees that due to the development in the legal position over the last few years, they really should have been receiving their normal pay, including overtime and allowances. But you're now in dispute. So you've agreed the principle that, yes, we've been underpaying holiday, but you're now in dispute about how many years back their claims for holiday pay can go, including whether the underpayments are broken by a 3-month gap in the series of deductions. So, case like this, how far back can the employees claim? Is it A, back to the most recent gap of 3 months, as that's when the chain of deductions is broken? Is it B, back to the first underpayment, regardless of how far back that may be? The chain has not been broken as the underpayments were factually linked to the same common cause. Or is it up to 2 years, the chain has not been broken as the underpayments were factually linked to the same common cause, but there's a statutory 2-year long stop? Or is it D, up to 6 years? And how did the voting look? 64%, an overwhelming majority went for D there, up to 2 years. The chain has not been broken as the underpayments are factually linked. But there is a statutory stopgap. And so everyone that said that, which, almost 2/3 of the room, that is the correct answer on this one. So up to 2 years, the chain hasn't been broken. This is the case, and it's a pretty well publicised case. This one, a Northern Ireland case, the Chief Constable of Northern Ireland, no less, against Agnew. This is a Supreme Court decision. And the reason some of those answers are in there is because this case has debunked certain previous cases that we've been dealing with. Going way back, I didn't look it up, but if I had to guess, about 10 years or so, someone will no doubt correct me. The Bear Scotland case was the first well, not the first, but the first really significant case that we had in a string of cases around holiday pay. And in that case, the judge kind of just made up this idea that if you had a gap of 3 months in a series of deductions, that broke the series of deductions. I think with the best of intentions, because he was looking for some way to limit the impact of the case, which was otherwise, you've all been underpaying holiday for a very long time. This case, the Agnew case, overturns that. So just the fact that there's a 3-month gap is no longer enough to break a series of deductions. Nor is one lawful payment. So if you have one holiday pay period, one pay period where you pay the right amount for some reason, that won't break a series of deductions either. The fancy lawyer language, contiguous payments, so payments next to each other in a string, may suggest a series of payments, but a series does not have to be contiguous to amount to a series. So you can have gaps, you can have periods where there's gaps in underpayments or the payments are correct. Yeah, if you've got a long series of unbroken contiguous payments that are all underpaid, that's a pretty good indicator that there's a series going on, but the absence of that won't stop there being a series in itself. And what the case says is that it's, of course, a matter of fact. They pay these people in the Supreme Court a lot of money to come up with what's quite obvious. It's a matter of fact whether something amounts to a series of deductions or not. And one of the things, and the key thing that they said in this case, is that it will partly depend on identifying the common fault that links each of the underpayments. So in the Agnew case, the payments were very deliberately calculated in a particular way, which, when they started making those payments, was legally correct. But it was always the same calculation payment for the calculation of the payment for the same reasons. These weren't random errors or something like this. It was a deliberate policy of how the holiday pay would be calculated. And it was consistently, once the law had changed, it was consistently wrong. And so that gave the Supreme Court comfort that this really was a series of deductions. It has been a significant case. Just to illustrate, if, as was argued by the Chief Constable of Northern Ireland, a 3-month gap would have broken the payments, the liability would have been about £300,000 for them to go back and pay everyone that had been underpaid. The finding of this case increased that liability to about £30 million. So that's probably a few less bobbies on the beat in Northern Ireland for a little while that backlog is paid up. So it is massive. It's mitigated a bit, though, because the reason it was so expensive in Northern Ireland is that the long stop piece of legislation, the deduction from wages limitation regulations 2014, has never been implemented in Northern Ireland. So Northern Ireland, the correct answer would be you go all the way back to the start of employment because there's no long stop on the series of deductions. So if the deductions series has continued, you can keep going back. In this case, I made the point in the question in the fact that the contract of employment said that holiday was based on basic pay only. You occasionally get contracts that say something different, and that actually the contractual position is that all pay should be taken into account. In those circumstances, even though an unlawful deductions claim in the Employment Tribunal can only go back 2 years, there is potential for people to bring a claim going back 6 years for a breach of contract claim in the civil courts. While it's almost always going to be the case that it's a 2-year backstop in England, Scotland and Wales, you could get a contractual claim that goes back a little bit further than that.